Hi, this is Nissan presenting Luis G. Gemudiano Jr. versus Naess Shipping Philippines, docketed in GR number 223825, decided on January 20, 2020. Facts of the case. In December 2012, Petitioner applied with Naess Shipping for possible employment as seaman upon learning of a job opening in its domestic vessel operations. He had an interview with Naess Shipping and completed the training on International Safety Management Code. On February 18, 2013, Petitioner and Respondents entered into a contract of employment stipulating that it shall take effect on March 12, 2013. Subsequently, the parties executed an addendum with an agreement that said addendum shall form of employment. But Respondents cancelled Petitioner's embarkation and informed him that he would not be deployed because of his existing medical condition, which he failed to disclose. Thus, Petitioner was not able to leave even though he duly passed the physical examination and was declared fit for sea service. Hence, he filed a complaint for breach of contract against Respondents. Issue: whether or not there was a breach of his employment contract that warrants his claim for unpaid wages, damages, and attorney's fees against Respondents. Ruling: yes, in the instant case, there is no doubt that there was already a perfected contract of employment between Petitioner and Respondents. The contract had passed the negotiation stage, or the time the prospective contracting parties manifest their interest in the contract. It had reached the perfection stage, or the so-called birth of the contract, as it was clearly shown that the essential elements of the contract, consent, object, and cause, were all present at the time of its constitution. Petitioner and Pedro, Respondent's crewing manager, freely entered into the contract of employment, affixed their signatures thereto, and assented to the terms and conditions of the contract, under which Petitioner binds himself to render service to Respondents on board the domestic vessel for the gross monthly salary of 30,000. An examination of the terms and conditions agreed upon by the parties will show that their relationship as employer and employee is encapsulated in the perfected contract of employment. Thus, by virtue of said contract, Respondents and Petitioner assumed obligations which pertain to those of an employer and an employee.